First, you're going to hear from Al Huang, Environmental Justice Director, Institute for Policy Integrity, NYU School of Law. Then Sheila Foster, Professor of Climate at the Columbia Climate School. Rachel Godsell, Distinguished Professor of Law and Chancellor Scholar, as well as Director of Research and co-founder of the Perception Institute. And Dana Johnson, who was until very recently Senior Director of Strategy and Federal Policy at We Act for Environmental Justice. I'm going to encourage you all to find their bios in the Whova app. You'll definitely want to follow their work going forward. Just a little bit of an overview of how this is going to go. We're going to hear briefly from each of the panelists. First, an overview of some of the key court decisions from Al and Sheila, and then some overarching framing and commentary from Rachel and Dana. And then we're going to get into the discussion with ample time set aside for questions. So please share your questions, however you're watching, whether it's YouTube or through the app. And my understanding is that they will be conveyed to us. So I think we're going to get into it. And I'm going to start by pinning Al, and then I will, oh wait, maybe I'm spotlighting you. I'm spotlighting you, Al, for everyone. And then you will, I'm going to just hand it off to you.
I'm sorry, somehow it did something here. Oh my God. There we go.
There you go.
Hi, everyone. Welcome. We're really excited to get this panel going. I'm going to cover part of the recent Supreme Court decisions that are going to impact, we believe, environmental justice. I'm going to focus on the cases that minimize powers of federal administrative agencies, and we'll talk a little bit about what that means. And then Sheila's going to talk about the big civil rights case that also has an impact on how the federal government considers environmental justice. So I think it makes sense first to kind of get into what is this all about? What are these cases all about? And really, it's about the role of federal agencies in implementing and enforcing our laws. So as many of you know, when Congress passes a law, in that law, it often delegates rulemaking and enforcement authority to specific agencies to achieve the law's goals. If it's a Clean Air Act, it'd be air quality, and so forth. And since Congress is not equipped to micromanage the day-to-day administration of every law that passes, it has to rely on federal agencies that are part of the executive branch under supervision of the president to carry out the laws and policies according to their best good faith interpretations. The reason being is that even when Congress is very specific and precise when they write a law, how that law is going to be implemented has multiple possible readings and often requires technical scientific analysis to be implemented. There aren't engineers writing the laws. There aren't air quality scientists. So oftentimes they delegate those kind of readings to the federal agencies, like an EPA or another federal agency. And then the role of the court, and this is a separation of powers issue, is to resolve arguments about what the law means and to evaluate whether they're being enforced properly or whether an agency has exceeded its authority to carry out the mandates of the law. So that's kind of from law to how it's implemented, the process and the role the agencies play in that. So what you hear a lot in this discussion is this idea of Chevron deference. This was a concept that existed for about 40 years in administrative law. And basically what it said is that it defers to the expertise of federal agencies on how to interpret ambiguous language in laws pertaining to the work. And then under Chevron, the role of the judge was to determine the meaning of Congress's law in order to settle disputes. So Chevron in this case would challenge a rulemaking and say that the agency acted outside of their authority. And then a court would look at, well, what did they do? And there was a test in how they would do that and determine whether they were acting outside or within kind of the meaning of what Congress intended. So the first major case that began to chip away at this Chevron deference, and we'll get to why this all matters, is West Virginia versus EPA. And this was the Clean Power Plan that EPA had promulgated. And the court held that in 2022 that EPA lacked the authority under the Clean Air Act to impose emission gaps that would shift energy production from higher emitting to lower emitting producers. And it said that generation shifting approach represented a major question of extraordinary economic and political significance, and held that an administrative agency like EPA had no power to make these decisions, because these major questions only can be addressed when Congress clearly gives the authority to the agency to address it, the clear statement rule. So they're pretty much saying that, there's the Clean Air Act, and then EPA interpreted what they could do under the Clean Air Act to write this rule. And then what the Supreme Court was saying was that, unless Congress is very clear for major questions such as this, then EPA had exceeded its authority. And then this is where the major questions doctrine appears. And it applies not only to rules, but also to policymaking as well. And although it didn't completely gut Chevron, it's starting that process of taking away agency power and putting more of that interpretation of what Congress meant in the courts. Next up, we have in 2024, this is, you've all probably heard of this, is Loper Bright versus Raimondo. This is where Chevron directly gets overruled by the Supreme Court, and it found that it was incompatible with the Administrative Procedure Act, which is the law that dictates, the process in which rules are made and which they can be challenged. And it tasked federal courts alone with, quote, deciding all relevant decisions of law, interpreting constitutional statutory provisions, and determining the meaning or applicability of the terms of agency action. So it's actually going even a step further than the major questions to say that, federal courts are the final word in interpreting that. And it said that Chevron was misguided because agencies had no special competence in resolving statutory ambiguities. And even when those ambiguities implicate a technical matter, that's kind of what I was saying before with some of the driving force behind the Chevron, because courts always had the benefit of parties having experts and whatnot, steeped in experts in that, to be able to explain to the court the different aspects of the issue at hand. And so what this did is it left solely to courts the ability to determine what the best reading of an ambiguous statute was, rather than assessing whether the agency is reading one of multiple permissible interpretations. So again, shifting a lot of that authority and discretion and expertise of an agency to the court to interpret. Also of note is Corner Post, which also happened in 2024. And what this basically said was that any rule, no matter how old, is open for judicial review and rescission. And again, held that the Administrative Procedure Act's 6-year statute of limitations for facial challenges of final regulations don't begin until a plaintiff is injured by a regulation, rather at the time that the rulemaking is final, which essentially opens the floodgates for challenges to longstanding federal regulations. Normally, the rule is finalized, and then you have a period of time to be able to challenge it. And if you pass that period of time, you can't challenge the rule anymore. What this case said was like, actually, no. I mean, if you're injured later by the rule, then you could go back and challenge it under one of these theories I mentioned earlier. So what does this all mean for environmental justice? First of all, I think the sum effect of these decisions is, as I mentioned earlier, shift power from the regulatory agencies, where the public plays a key role in shaping those policies through elections, electing in folks into the executive branch with their priorities, but also the whole process an agency goes through to promulgate a rule, notice, comment, hearings, whatnot, and then shifts it to the federal courts, where regulated entities consistently challenge government action and the court can invalidate the action. And why is this for environmental justice particularly concerning is that most of the legal and policy authority to consider EJ in federal decision-making is through presidential executive orders, and then agencies promulgating policies around that, not from laws passed by Congress, which is an issue of politics, Congress not being able to build a consensus to pass EJ laws. So that makes EJ actions very vulnerable to major question doctrines type challenges, as well as Loper Bright challenges, because they're coming from the executive branch and the agencies, and these challenges, these cases essentially open the floodgates to challenge these policies and actions and law and regulations done by agencies and the executive and validate them. And so what it also can do is it can stall major federal regulations for long periods of time. So as I was saying before, you can go back and challenge them. You could also challenge, now there's all these new challenges you could bring to regulation to invalidate them, which would put protections for communities at hold and potentially at risk, existing and new ones. In addition, we've already seen legal challenges to agency, mainly EPA, EJ authorities, programs, and policies under these legal theories I just mentioned before. There's the state attorney generals led by Louisiana petition to EPA to challenging their Title VI of the Civil Rights Act of 1969 programs, and also raising major questions, issues about whether the administration has the authority to consider environmental justice and civil rights in how they address environmental protection, as well as recently state AG lost. Oh, no, I mentioned that one already. So there's these actions are already on the table. So this isn't theoretical. This is happening already. And what this might have, and I think it has done already, will make the case, is that it's created a chilling effect on the ability, scope, and advancement of EJ considerations in government decision making by agencies moving forward. I think a great example of that is how in Justice 40, which is the federal requirement that at least 40% of funds that go to disadvantaged communities for around energy, climate related things, they took race out of the definition of who is a disadvantaged community that can get those funds, primarily because of concerns with these types of challenges. And Sheila's going to talk about the civil rights one next, which is the other one as well. And then finally, communities can be sidelined by many of these challenges over rules with major EJ impacts, as courts consider their own factors in deciding whether government action is permissible. So, I mean, now you're getting these, they're going to be litigated. And there already always was litigation over these rules. However, what these cases do is they open new fronts of litigation that can lead to complete invalidation of a rule or regulation that an agency has promulgated. And in courts, communities don't have the same sort of access they do and procedural justice protections as you do perhaps in the agency process. So, really, it's kind of taking that power away and then limiting community access there. And I think Dana's going to talk a little bit about that down the line. So I'll now pass it over to Sheila to kind of talk about the other big case that affects civil rights.
Great, thank you, Al. So I'm going to talk about the recent opinion by the Supreme Court on affirmative action, Students for Fair Admissions versus President and Fellows of Harvard College. Can I move forward, Al, or must you move me forward? Okay, there we go. So yes. So this was a challenge to the Harvard and University of North Carolina's race-conscious admissions process. Both Harvard and UNC explicitly, as many universities in their affirmative action programs in their admissions process did, considered the race of applicants as part of a holistic admissions review. Next. And the way that they did so was a little bit differently, and this gives us a clue as to how expansive this ruling might be in terms of the court's reasoning. But Harvard considered the race of applicants in a bit of a stronger way to look at the bottom line numbers after the assessment process to make sure there was no dramatic drop off in minority admissions from the prior class, meaning that there was some attempt to make sure there was no retrenchment of the number of students. And so race, the court found, was a determinative tip for a significant percentage of all admitted African-American and Latino applicants. UNC treated race more as a factor and a substantial plus, depending on the applicant's race, not as strongly as Harvard in terms of aligning the numbers at the end to ensure specific outcomes. Next. So this case is one in a line of cases around affirmative action, and the two most particular ones were the case that established the constitutionality of universities using race in this way in the admissions process, the Bakke case, and the other was a case that reaffirmed basically the reasoning of Bakke, but also the court relied on in this case to say that affirmative action should be coming to an end at this point. This is the Greta versus Bollinger case. Click through, yes. And in these cases, a number of principles came out of them that the court either pulled back on in this case, or at least they may have kind of titrated their ruling around how much these principles are so active. So one is that universities have a compelling interest in obtaining the educational benefits from a racially diverse student body. that race can operate as a plus in a more holistic process in admissions, that it's clear that you cannot separate out applicants by race and have a two-track admissions system, but you can be race conscious. Al, next. So I already said this. So you can't reserve specific seats. Next. And that universities cannot use race to foreclose an individual from all consideration in a way that harms non-minority applicants. And this is a particularly important point that the court leans in on here. Next, Sal. And in the Greta versus Bollinger case, the court expressed its expectation that in 25 years, the use of racial preferences will no longer be necessary. Next slide. Okay, so I'm going to go through this quickly. So basically what the court held here is that both of these processes were unconstitutional because they do not advance compelling enough interest to allow the use of race. Instead, the court felt that they risk treating applicants in a stereotypical way. Next. Some of the interest that the university cited for why they were using race was, and why they wanted a diverse student body, was to train future leaders, to acquire new knowledge based on diverse outlooks, to promote a robust market of ideas, and to prepare engaged and productive citizens. The court ruled that these were not sufficiently coherent and that there was no way for the courts to measure whether these had been met. Next. And the court found that the use of race harmed other racial groups, in particular Asian American, and again felt that it was based on the assumption that students of a particular race think alike. Next. And picking up on the Greta versus Bollinger language, they ruled that the race-conscious admissions program should be coming to a close and that neither of these programs had a logical endpoint. Next. So what does this mean for, so in the end, it's a 6-3 decision. The majority left open, there's some language leaving open the use of race in admissions, that these programs can consider race only to allow applicants to explain how their race concretely influences the quality of their character, or concretely that they bring unique characteristics to contribute to the university. So there's some openness. So in the end, does this mean the end of affirmative action at universities? I think what we're seeing now is that, yes, it has meant the end of considering race in any robust way at university. Does it mean the end of race consciousness in programs and policies? I don't think so, but I think the trick is, and here there's some interaction with Title VI and civil rights law, which we see at work at the EPA, and we can talk about this later. One of the compelling interests that the court has upheld for the use of race is to cure prior discrimination. And if there are anti-discrimination laws that agencies are finding that there is discrimination and permitting, for instance, in the environmental justice context, arguably, there may be some toleration judicially for the use of race to get at that. But yet what the court evinced here was clear hostility to the use of race in government programs and in any program that's receiving federal funding by definition, and impose an exacting standard for when race can be used that really opens the door to court challenges. And I think we're also seeing that. And this will create, I think, risk aversion on the part of government agencies and bodies. And we've seen that in this administration in terms of their willingness to use race in screening processes or in programming. So I'll stop there. I'm out of time and kick it over to Rachel.
Hi, everyone. So we're going to move from the courts to the conversations that often happen when courts make decisions. And what you see in front of you is two messages that a group of us with Perception Institute, that included the Othering and Belonging Institute and the ACLU, tested before the Supreme Court decision that Sheila just described was decided. Because in candor, what we were worried about was, we all knew what the Supreme Court was going to do in the SFFA case. There was a lot of concern, worry, anger, frustration that the Supreme Court was going to do precisely what it did. But then the question became, what do we do next? And when I say we, I mean people who care about racial equity, people who care about the opportunities students are going to have to be in educational institutions of the sort that they think will serve their interests and allow them to thrive, and that allows our country to have diversity within all of our educational institutions. And so you see two visions, and one that's called the outcome-based narrative is actually the ACLU's message on their website before the court decided. And this was a message that conveyed the moral urgency, the anger, and the frustration that the Supreme Court was going to rule against affirmative action, and the outcome that was anticipated that decision would have. And our fear, the group of us who were thinking about this, was that for the ACLU and the civil rights community across the board to say that when this case was decided, a generation of Americans would essentially be shut out of elite institutions would actually potentially have the effect of contributing to that harm. So this message that you see, a Supreme Court ruling against affirmative action will harm a generation of Americans. It will almost certainly mean a steep drop in the number of students of color being admitted to selective universities. That's what's already happened in states that have outlawed affirmative action. Now, there was, of course, truth in that statement. And yet, the worry was, if that was the statement that framed everyone's interpretation of this case, what it could lead to were students deciding, and teachers and parents and caregivers and others who are working with students don't even bother to apply because you are being shut out, even though you are a fantastic candidate who should have the opportunity to go to the educational institution that you've been dreaming of for your whole life. So what we decided to do, again, this is all before the case came out, was to test a different way of talking about the issue that we call goal framing. So we would begin with what the goal, what the ideal is, which is a better future depending upon people across walks of life, respecting each other, working together, and doubling down on people's chance at a good life. Acknowledging all we hear about is division. But there are signs of progress. There's some hope. We've seen, and this is true, this is all based upon fact, when colleges create opportunities, students across race, ethnicity, and income step into them. Astronomy, engineering, medicine, teaching, or the arts. And then giving some examples. There's been a growth in Black and Latino Americans majoring in science and engineering, colleges creating new opportunities for people of all backgrounds, students in rural areas like Appalachia to first-generation Asian Americans. We're all in this picture. And then, frankly, acknowledging this, what the Supreme Court might do, no matter how the Supreme Court rules, colleges should keep this up, because what we wanted to say was, we've got to keep this momentum toward inclusion and opportunity going. We can't let what the Supreme Court does dictate what colleges will do. And here was what the results were of the test in the next slide. So what we saw was that among our questions were, what would the result be for students of different races and ethnicities in considering whether they ought to apply to elite educational institutions, whether there was a chance that they would be considered fairly? Not surprisingly, with the outcome frame, only 37% of young respondents of color thought there was even a chance that they would be considered. With the goal frame, 60% of respondents of color. This was students of color across race and ethnicity between 18 and 25. So that was our hope, was we wanted people to continue to think of themselves as potentially having that opportunity. And then the onus would be on the colleges and the universities to construct admissions opportunities that would give everyone a fair shot. We didn't want the Supreme Court to take the opportunity away, and for that opportunity to then lead to students not putting their hat in the ring, and so the precipitous drop potentially being occasioned in some way by the anticipation of what would come. The other element that we feared with the outcome frame is that, frankly, we are operating in a world in which the dominant negative stereotypes about race and ethnicity are all around us. And there is a risk of decisions like the Supreme Court's and then the anticipated drop for some people confirming those negative stereotypes. And so one of our questions was, in reading these messages, is there going to be a potential risk of stereotypes being confirmed? Or to the contrary, can we push against those stereotypes so we continue to push toward a society in which no one is judged and presumed to have any quality that they lack because of their race or ethnicity? So the goal frame message resulted in a 15% greater likelihood of rejecting racial stereotypes. So to move this from the context of education to, broadly speaking, where we all are in the environmental justice field, on the next slide, this goal framing is a different way for us when we're talking about the issues that we care about most to potentially make a political move to bring more people on board. And so begin with, what is your audience feeling? Because we can't seem naive if we just begin with happy goals in a moment in which people are feeling, obviously, an incredible degree of frustration, anger, and the worry that our political process is continuing to leave some behind and to be polarizing. So acknowledge what that feeling is, but then stating the goal of, again, clean air and clean water for every community. That's the goal. And examples of where we've achieved this. So the political momentum, the sense of possibility exists, and there's not a sense of this is all intractable. We have no basis for hope. So the political organizing may feel like it's not even worth the efforts. But then obviously be really clear. What are the challenges? What are the challenges of racism? What are the challenges of how, again, communities of color or poor communities are being treated? What are those challenges? And what's the call to action? And what's the goal? So this sequencing can do something powerful, which is it can name where we're trying to go, acknowledging that there might be a lot of frustration about our polity at the moment. It can name all of the sort of obstacles we're seeking to overcome in whatever way, with data, with descriptions of cases that we're having to, to address, with all the challenges that Al and Sheila just discussed. But we have to keep a way for people to stay in the work. And the concern is that if we begin with the sense of harm and the anticipated outcome of, frankly, the success of those who are trying to take away rights, we run the risk of creating a sense of intractability that will be hard to overcome. So look forward to having a continued conversation about how we bring all of this into the work of EJ in a way that will lead to change, despite what the Supreme Court is doing to undermine our efforts.
And Dana, I will hand to you. You are now spotlit. And from your vantage point, what are you seeing as the implications for advocacy in the long term?
Yeah, so thank you, Al, Sheila, Rachel, for setting the stage. I think what I want to talk about is the scene that we were operating in or have been operating in as decisions are being made around these, these particular court decisions are being finalized, but what we also were doing on the advocacy front and things that we are considering, how we think about moving forward. So just from my perspective, I will say what we see happening now is the fruit of work that goes back to when we saw voting rights, civil rights, environmental laws, permitting, et cetera, put into place. They have been under attack because those are some of the tools used to empower people. So the past 5 years or so, we saw two administrations in play. And the scene that we were operating in was, COVID-19. We saw long-term exposure to particulate matter, increasing people's death rates when it came to exposure. We saw a new crescendo in racial reckoning in this country with the murder of George Floyd. By the time we got to November of that year, we were in election period that feels very much like the one we're in now. The glue that holds us together as a nation. So these laws, these bedrock laws that you all have talked about, we see them being weakened, and we worry about their erosion. But there's also that feeling of instability, I think, that comes with it. I felt that very much when Al was talking. And so by the time we got to a Biden administration, we saw 100 just on the environmental front, air pollution, permitting, land use rules be rolled back in some sort of way. We saw the challenge, the impact of the challenge of the Clean Power Plan with EPA versus West Virginia come to fruition. And I think from the community perspective, it put us in a really tough place because we saw the EPA put out a proposal for 111B and 111D that frankly felt like it was built off of a premise of harm. So we're going to use carbon capture and sequestration and hydrogen as ways to reduce emissions in communities. So essentially, we're trading carbon for other criteria pollutants, and that was unacceptable to us as a community. As was mentioned, we were put in a place where investments in communities, or disinvestment, quite frankly, that largely based on race was not being considered when we thought about remediation and revitalization in communities. And so the Supreme Court decision that Sheila talked about was in the backdrop of our advocacy as we were trying to take advantage of this moment. But there were also whispers around, like, we shouldn't talk about Title VI because we don't want them to attack it when, frankly, going back to my first point, anything that empowered communities was under attack or is under attack in this moment. And I think also in the backdrop was we were going to operate from a place of power. So we knew that these decisions were coming down. They were likely not going to be in our interest. But one of the things that I was committed to was ensuring that environmental justice was at the forefront in these rulemaking processes. So we organized people around 13 rules that the EPA was updating. 3 of them related to medium and heavy duty trucks, 9 of them related to the energy, the power sector. And when you look at the dockets, as Al mentioned, of submissions on what we wanted to see happen with how these rules were strengthened, how they met this moment, you will see environmental justice listed. You will see environmental justice organizations, communities participating in hearings. You will see legal interventions by us because it was important for us to continue with business as usual, continue to up our advocacy, and to not, as Rachel mentioned, sort of cower because we were in a moment where those things that were important to us were under attack. And so I think the things that we are still considering and contending with in this moment. So in addition to what Al mentioned around the Louisiana lawsuit, in March of this year, we saw 24 states sue the federal government. The federal government sued the around the soot rule, which is one of those rules that was updated in this current process. On the permitting front, we saw 20 states in May sue to stop the CEQ update to phase 2 of the National Environmental Policy Act process, which is critically important to us because there are, for the first time, environmental and climate justice considerations that can be a standard for future rulemaking, even in Congress, when it comes to having a codified definition around environmental justice and climate impacts. And so I think for us, we are continuing to engage in the process from a community-based perspective. There is this fear around the weaponizing of laws. And so just the knowledge that cases can retroactively be revisited is something that's concerning, and it brings up that instability. And so it has us thinking about how do we talk about these things. It makes us think about the appropriations process, quite frankly. So how can we ensure that Congress is investing in enforcement and oversight for what we do have on the laws, that agencies and departments have the resources that they actually need to do their work? And then my sort of like out there idea, I know that came up in our prep, was, how do we turn our advocacy toward the courts if we feel like that is the place where a lot of the decision-making around our lives will be made? And so, I don't know if it's like a one-to-one sort of shift where, you are, sharing information and data and science and, first-person accounts, et cetera, with the courts in some sort of new way. I think traditional tools like, submitting an amicus or a brief can be pursued, but I do think that we need to think about how we um, focus our advocacy in a way that sort of takes us outside of traditional bounds and has us really evolving with the moment. So I will stop there and look forward to the conversation.
Thanks, all of you. I'm really sitting, Dana, with what you just said about that anything empowering communities is under attack, and it really does feel like that. So I'm going to start with a question for everyone, and I'm going to say, let's start with Sheila, then Dana, Alan, and Rachel. Anything you want to add on this question? You've all shared a little bit on this, but what are the implications for these court decisions, both at the Supreme Court and some of the lower court decisions as well, on the advancements that we've made on environmental and climate justice? And I just highlighting the fact that we have made significant advancements over the past several years, and even in the very recent years, with the new executive order on EJ, with the executive order on racial equity, with Justice 40 commitments, all of that. In light of these advancements at the state level, et cetera, what do we need to be worried about in terms of how these decisions might be interpreted? What should be on our radar? So Sheila, I will start with you.
Yeah, and then I appreciate everything that Dana said in particular, so thank you for that, Dana. I think you framed it exactly right. So I think three things at least. I mean, one, and I think Alice talked about this, we've all talked about this, it's the use of these decisions to attack where we've made progress, right, and to roll back. I think we're going to continue to see that. This has been the most consequential administration for environmental justice, and along with, all of us, we've been in this and we've seen all the ups and downs. So I think that's under threat. Number two, I think that attacking the civil rights laws in and of itself, Al talked about this, the Louisiana case, right? And, at the universities, we're seeing, Title VI, a law that's been designed to, create opportunity being used to hold universities to task in these days for, the whole protest situation and threatening their funding. So I think that the use of laws that were designed to protect our communities, and notably that are not kind of part of the SFFA decision, in the sense that it's not about equal protection standards. It's about, are you discriminating because of race? And every federal agency had Title VI regulations, and the EPA and other agencies have tried to use those to protect communities. But I think that turning those laws, kind of upside down. And then third, I think, what we've seen is a move already, and I wrote about this a long time ago, toward these kind of indices, these vulnerability indices that try to get at the intersectional harms, that it's not just race and class, but it's a whole host of things: where you live, what you have access to, and histories of redlining, et cetera, that put people in particularly vulnerable situations that classic civil rights and race discrimination law has not been able to reach. And I think the EJ screen and all the ways in which we're trying to capture that. And I'm not sure how these decisions threaten those, but I'm sure someone will try. And I think we've seen that the administration, did not use race in its, screening, and that's that kind of risk aversion that I'm talking about. So over to, I think, Rachel, right, or Al.
Dana, I'll hand it to you.
Okay. So I think Rachel, the biggest thing that I see is what Rachel brought up. It can potentially put us in an environment where the instability and the safety of what we thought you could rely on, like an objective process, will paralyze people. I think it'll be preservation of the status quo. So you will have agencies and departments that won't know what to do, so they won't do anything. I think that we potentially will, we are seeing how important it is for who sits in these seats, these judge seats at every level of government. And I think that we will see court hopping, right? People will keep moving around until they get to a court that gives them a decision that they want. We saw that with Mountain Valley Pipeline. It ended up, having to go to Congress to get the decision that they want, that industry wanted. We see that with the soot rule. Usually that case would, I believe, be in the DC circuit. It's in Wyoming. And so for us to even intervene, we thought about that. We're intervening in a case in Wyoming where none of the EJ groups that we work with are in Wyoming, but it's important for us to be on record. And I will also say there was a lot of consideration around what would be our organizational and personal impacts intervening in some of these decisions, because we didn't want to be attacked as a result of that. And so that goes back to that thought of being unstable.
Absolutely. Al, do you want to go ahead?
Sure. Well, I think obviously, like I mentioned these in the slides. I mean, the chilling effect piece. I mean, but I mean, here's one thing I do want to give. I mean, yes, the Supreme Court and some other more conservative judges have supported these theories and created new precedent around them. It doesn't mean that every time they raise it, they're right. Like, these major question doctrine challenges around Title VI. I mean, like, there is a test. It has to be unheralded and transformative. I'm not sure Title VI programs are unheralded. They've been around for over like 40 years. There's regulations in the book. DOJ I mean, there are responses to fight back to some of these things, but the fact of the matter is, and we should continue doing that and reminding those who are in power, because I mean, the practical effect, and this is what I think those in the folks who are fighting this stuff fighting against this want, is that they want the federal government to step away, and they want them to minimize what they're doing to affect environmental justice in communities and around permitting, around siting, around all these things. They want to push out these issues, and it could have a significant effect. I mean, I just think about, like, right now, we consider environmental justice and regulatory rulemaking, and under NEPA too, as you were pointing out, Dana, but like very rarely, if ever, I think there's only one, does that, whatever determination they make, that, oh yeah, you're right, there are environmental justice impacts to these communities, how often does it actually change the outcome? And it doesn't happen often now, because there's always been concern about being challenged for, like, where's the authority you have to have race be a factor in that? What these cases do is it pushes out that fear for the agency. So I think as advocates, we have to be in there and remind them, here are where the corner posts are, and elections matter, and we have to push for folks to go out and continue pushing aside from the risk of being challenged, because I think it's going to happen regardless. Not just anything environmental justice, anything climate is going to get challenged too, right? And that can't be the reason why we don't address climate, right? I don't think anyone intends to do that. We need to have the same thought process for environmental justice, right? And make sure that these executive orders, which is what we really have, continue. And I mean, I haven't seen challenges to these executive orders yet, but I mean, all it takes is a big issue to come up, and maybe someone wants to challenge as well. So I think those are the things, and I think Dana, I think 100%. I mean, like, the solution to part of this is going to come from the communities and from advocates, obviously. And I kind of like what you were saying earlier about what is the long strategy on this. And a lot of this, it is in the hands of judges, right? And how do we democratize that? How do we get jurists to understand these issues, what their impacts are? These are not just these easy administrative questions. These are people, these are communities, there's health involved here. So in my mind, I mean, I think I totally agree with you. There needs to be a strategy building that's a long-term, because, these judges that are making decisions, they're not going, many of them were just appointed to the bench. They're not going anywhere. They're going to be there still. And so we have to think about where are we going. And in some ways, where we got to today was because there was a grassroots strategy to figure out how to get these jurists in there from the right. And so, and to make them prioritize things like gutting civil rights protections, gutting administrative discretion and expertise and abilities to interpret laws. So, yeah, hand it to Rachel.
Thanks, everyone. This is such a important conversation to be having right now, as everyone is indicating, because we are in this very crucial political moment. And I think, Dana, what you described about the role that communities have played and the environmental justice political movement has played since its inception is one that hopefully we can hold on to, because when EJ first started, as we all know, like it was not a movement that would have understood itself to be like a Washington insider movement, to the contrary, right? And so the irony here of us as people who care deeply about EJ being the ones to say, where is certainty? Where did certainty go? Like, I mean, it's so fascinating because, finally there was some recognition at, there in the agencies and other places that EJ is the only outcome that's going to bring, address climate change, the only outcome that's actually going to protect the health and well-being of, again, people across every community. We've known this for so long, right? I mean, Gerald Torres and Lonnie Guinier wrote The Miner's Canary a really long time ago, and that's exactly where we are. So it seems like, I think the point is real, so powerful about having judges when they are holding this much power, because it is bizarre that supposed conservatives are suddenly empowering the federal courts. Like, isn't that activist? I'm so confused, right? But in this moment where they have all this power, to Dana's point, to have them understand the implications of the power they're exercising as human beings, and then to think of their institutional role, we have seen judges change. We've seen justices change when they suddenly recognize Justice Blackmun was not someone who anyone would have ever have identified as being the author of Roe when he was first put on the court. But then suddenly the weight of human lives became real. The weight of women's lives became real to him. So I think that is an incredibly powerful political move. And then obviously there's just politics itself. And Dana, what you said about potentially, sort of engaging with Wyoming, like what an extraordinary idea of having, We Act, which has done such amazing work everywhere it's been, create bonds with communities in Wyoming who are going to be hurt by soot too, to be able to make different, kind of coalitions across, again, across class, across all sorts of divides. So it seems like, and I know this is, I'm seeming bizarrely like energized by all this, and I don't mean to suggest and to minimize everything that everyone is doing and all of the harm that is, people are having to carry because of these decisions. But I think what you described, Data, as like EJ coming in from a position of power and not ever cowering. EJ has never cowered, and so hopefully we'll see this as an opportunity to keep pushing forward in really creative ways.
I really appreciate that. And I think, and I also appreciate, Rachel, you kind of bringing us back to the origins of the movement, because as you were describing the goal-oriented frame earlier, all I kept thinking about was the environmental justice principles, and that the environmental justice principles are where we are heading to. They're about a vision of self-determination. They're about a vision of right relationship with Mother Earth. They are about a just world. And where we are heading. They're not the picture of injustice where we are right now. And so I think always coming back to that frame, I think is very helpful. If we can educate our judges on that vision, that also would be very helpful. I want to just take a moment to kind of come back to this question about, we've talked about a little bit, Dana, about, with courts having a stronger role in interpreting regulations, with this, this shifting dynamic around the administrative state and agency decisions, what can EJ communities do to influence these decisions and ensure that they result in the solutions we need? So I'm going to go to Dana and then Al, and then I've got a question teed up for the full group after that.
Yeah, so I think EJ should continue in what it's doing. So I think we should continue to rely upon, legal experts and partners if they're in our organizations, which again, that was one of those things that was critical. It was important for me to ensure that we had as we engaged at the federal level. Like, let's have our own attorney and let's, make that resource available to other communities. But there are law clinics, et cetera, across the country that, even more than ever, environmental justice will be reliant upon you. We should continue those partnerships when it comes to research and data, and being able to, demonstrate impact, challenge, modeling and sources of science that we know or believe don't speak fully about the impacts of, pollution in our communities or the siting of a project, et cetera. I do think that storytelling, humanizing, as we've talked about earlier, the impact of these decisions or not doing something that, communities are calling for will be important for us to continue to do. So I don't see a big shift in what we've been doing. I just see an expansion of the stakeholders that we work to engage. And then just one really quick thing. I don't know if anybody has ever felt this before, but last year I remember reading the 17 Principles of EJ for, I don't know, the umpteenth time. And it very much felt like the Declaration of Independence to me. Like it was the movement's declaration, as you said, for what it saw itself being, what people saw themselves being, but also the future that they wanted to have. And I wondered if there was intentionality around it. And just in talking with, Vernice Miller Travis, with Peggy Shepard, they were like, I don't think we thought about it in that way, but that's how it feels to me. So I'll pass it on.
I'm not sure how much to add to what Dana has already said. But I mean, I'll just like bolster. I think 100% stay the course and push harder, and I think there's always going to be lawsuits. I mean, like any environmental major rule or law, there's going to be lawsuits, and now we just have new theories to deal with, and I think it's becoming well equipped, especially those who are in their spaces in the courts arguing them. To be well equipped to understand the EJ intersections, implications, like Dana's point, the storytelling piece as well, and how they fit into, what does it mean to invalidate, like protections for people, right? So I think that's all I have to add to that. I mean, I have nothing else to say. I mean, I think Dana has got it hit the nail right in the head.
And Dana, I want to hand it back.
Yeah, I want to make one other selfish plug. So when you think about environmental justice, it's very intimate, it's very on the ground, it's very place-based. And the intentionality that movement elders made around, we won't have a centralized movement, if you will, but everyone will go back to their communities and do their work. I would offer that this might be the moment for us to think about a both-and strategy. So not being at the federal level, one, felt very lonely. But two, we need to have more people power at the federal level, as we are seeing. People need to be at all levels of government doing this work. And, that speaks to like more investment in organizations or more parity in investments. But we have to be at every level of government if we are going to tackle this in a meaningful way.
Absolutely. This is the moment that for the folks watching, I'm going to make the pitch for questions to come in. You can put them in the Whova app. I think you can also put them on YouTube, and hopefully they will come to us. But I still have lots of questions for the group, but I want to hear for folks watching your questions. We want to hear your questions as well. So please share them with us. For the group, if anyone who wants to take this on, kind of shifting back to the SFFA case and related cases, as well as the challenges to Title VI, I would love to hear from you all about, what are the implications of taking race out of a race-based problem? And also, so thinking in terms of, the problem, the challenge, the backlash, but also in terms of the solutions in light of that, what the backlash, what models should we be using to address structural racism?
Rachel, go ahead.
Sure. And I'm actually going to build on something, Sheila, that you mentioned already, which is the various ways to continue. So first of all, SFFA, as Sheila said, doesn't say we can't consider racism. In fact, SFFA specifically says individuals who are applying can describe experiences that they've had personally overcoming and addressing discrimination. So I think if we think about that racism and the harm of racism and other harms linked to identity are still very much within the legal ambit. And second of all, Sheila described the use of indices that show existing harm from governmental decisions that are presently occurring, and that's something that obviously can be a different process, looking at situatedness. John Powell sometimes uses the word situatedness. If we talk about a universal goal and it not being race as a proxy for situatedness, but instead let's look specifically at communities that are have suffered from redlining, from underinvestment, that are overexposed to pollutants, that are under provided with amenities. Like, those are all very specific sort of identifiable factors that absolutely can and should be looked at in any of the contexts that we're talking about, and that in no way run afoul of anything that it currently exists in the courts. So it seems like we should definitely keep very aggressively pursuing all of the efforts that are already being pursued in that frame, and making sure that people don't, essentially, I think that it's been mentioned a couple of times, that we don't become risk averse in a way that is increasing actual risk.
And I will say a couple things. And one, I want to build off what you said, Rachel, and what Dana said. I mean, I was an early lawyer in the movement with Luke Cole. We were litigating Camden, Chester. And before that, Linda Bullard was litigating in, Texas. So we've always known that litigation in these cases were not winners. Like the late great Luke Cole said, lawyers on tap, not on top. It's always been a danger to, as Dana said, look, first of all, to the federal government, to the courts only, right, as the mover, the kind of force that's going to move us towards justice. Never been the case, but we've always known to put those strategies in the context of a larger movement. And the key thing on structural racism, and it's why I started working in communities and locally and not so much in the courts, is that law exists everywhere, not just in the courts, not just at the federal government. And when you're really trying to construct sustainable communities, you realize the various different land use law, state and local law, transactional law, really empowering communities using the levers of law. And if lawyers are on tap but not on top, yes, we're pushing back against what we've known since the 1980s. The courts are not ruling in favor, and even when we won for a moment the Camden case, and 5 days later, the Supreme Court came down and said, no, there's no private right of action on top. We've known that's not a winner, but we have to keep our eye on the prize, right? And I think the prize for EJ and climate justice, frankly, is creating sustainable communities and using all of the power and levers that we as lawyers are trained on to be able to hack the system. And you can't hack the system unless you understand the system and where the levers are. And that's how we should be training lawyers. And that's how we should be raising lawyers in this, because structural racism is not about the courts, right? It's about all the other stuff that we have to unravel. So that's what I'll say. And I think these indices, these vulnerability, the screening, I think they've been a really powerful tool in, getting that and naming that, right, what structural racism is and the intersectionality of that. Lawsuits have always been a way to name the problem, not to win justice. Stop there.
Thank you, Sheila. Dana or Al, either one of you want to weigh in here? You're good. Okay. I'm going to dig in just a little bit further on the both legal and kind of framing questions around civil rights and structural racism. In the context of constraints on equal protection and Title VI, there's a push towards requiring proof of disparate treatment or intentional discrimination, which we know has a high bar, but we also know it looks different. Intentional discrimination looks different in 2024 than in 1964. So what is that? How does that look different? How does intentional discrimination or disparate treatment look different now? And how do we tell that story? And what might it mean for future legal theory? So I'm going to go again to Rachel and then Sheila on this.
Thanks so much, Amy Laura. I think what we know, and this is actually in Supreme Court doctrine, if something can be shown to be because of race, it doesn't have to be because of, as you're putting it, old school racial animus. Now, we know that exists and that is looming large in our society right now, but individual decision makers at various points may or may not be in that camp. But if we can show that something is happening because of race, doesn't matter what people say their intentions are, that's a violation of the Equal Protection Clause. That's a violation of Title VI. And that is an existing doctrine. And so I think that one of the things that the sort of social science tells us about how our brains work is a whole host of things happen because of race that sometimes, and I'll just give an example from a case that litigated back at LDF. A incinerator was cited for East New York, Brooklyn. The New York State DEP gave a negative declaration saying they didn't need to consider the environmental impacts of said incinerator. When we brought that to their attention, we said, how is it possible that you said that there might not, that you could possibly say there didn't need to be an environmental review when you have childcare centers and senior centers and housing and all of these people so close to this incinerator? And these governmental decision makers were shocked. They're like, somehow they hadn't even thought of that. Now that was because of race. Even if they may not have thought that they had racial animus in their minds, that was very clearly because of race, because we could show from prior decision-making any comparable context would have involved a different decision. And so I think looking at the evidence of something being because of race, but not like having that rest in sort of someone's minds, because that what's in their minds is evident by their behavior as opposed to what they say or don't say.
Yeah, let me build on that. I think that's exactly right. I mean, there was a district court opinion in West Dallas that went with that reasoning that Rachel just said. It was on kind of a complaint dismissal, but it basically, the lawyers went in there and kind of told the story. And I think this connects to the storytelling function of the environmental justice movement. Really told the story of the history of a community, redlining, et cetera, zoning rules, et cetera, and how they really kind of primed that community for locating stuff there. And I think we have such good social science now that's connecting redlining to exposure rates, to heat islands, like all of the ways in which race has played a determinative factor in the vulnerability of our communities, that I think if we tell those stories, I don't anticipate it's going to win in court more, not, but at least it puts up, I think, a hell of a offense and defense in ways that get around this kind of conscious, this 1964, as you say, I mean, Laura, this smoking gun, like we have to find the smoking gun. Someone said, I'm harming you because of your race, which is the equal protection standard. That's not necessarily the statutory standard under Title VI and even Title VIII, the housing. So I do think we have these great strategies that are in our back pockets, and that we should increasingly look to interdisciplinary, like social science, the ways in which we are telling the story in very powerful, data-driven ways.
I'm really excited to build on. I've been waiting to ask this question of this group for a while, so I'm really intrigued to hear your answers. Alan, Dana, anything else that you might want to add on this question? And then I want to zoom out to the state, or zoom into the state and local.
Yeah, I think.
Go ahead, Dana. Sorry.
All right. So the one thing that came up for me when Sheila and Rachel were talking was, even thinking about like the carbon rule proposal, and from a environmental justice perspective, we kept wanting, like, it should be based off of EJ analysis and cumulative impacts, and that should, trigger the best system of emission reduction. But just listening to you now, legally, I believe it can't trigger like a particular path, but it can trigger perhaps like an all of government approach to how do you ensure that a community, that can't take one more thing does not get one more thing, and an all of government approach to how do you revitalize that community, after. So like those are, when you talk about more than just the law, but like the practice and the policy for how we do things, I hope that that's what we can get to, in this moment.
Al, did you want to have anything to add?
I guess, the only thing I would add is, like, I think the other kind of interesting angle on all this is the perpetuation of outcomes or situations in communities that were based on historically intentional discrimination, the failure to act to mitigate that or to perpetuate it, either through I think about what's going on right now with the Title VI complaint about I think it's Mississippi, it's Alabama not granting clean water revolving funds to any of the people of color communities. and consistently denying them when asked about it, and the funds going to white communities. That those kind of fact patterns that you're not your traditional intentional discrimination, those haven't been, I feel like, treaded out as much, especially in the environmental context, because these are like environmental type situations. You kind of have to like pull them apart to see what is the action, what's the discriminatory action. Those are other areas I think that maybe there's space to advance and get around and to advance a narrative about what is intentional discrimination in many different ways that it appears. Yeah, I'll just stop there.
And I would add to that, in addition to the revolving loan funds around things like water, disaster, disaster recovery resources, we have clear fact patterns from Connecticut to Texas, where wealth inequality and structural racism are being exacerbated in recovery from climate crisis, weather events. So definitely something I think we want to take a hard look on. Sheila, I will hand to you.
Yeah, just one point on all of this to underscore. So even in the disparate impact area, so the inclusive communities case that the Supreme Court had around the Fair Housing Act that had a disparate impact standard, they leaned in on this causation. They said, even though it's an impact standard, you don't have to prove intent. You have to show causation. And so this issue of telling the causal story is with us in this area, whether we're talking about intent or impact. So that's all I want to say.
And the theme of storytelling running through this whole conversation, EJ movement, very good at telling stories. And I think figuring out how we need to shift those in light of current conditions feels like a strong next action step. So one of my questions actually dovetails with one of the questions from the audience, which is kind of what are the implications of these recent Supreme Court and lower court decisions for state and local government? And I think I want to put this in the sort of both the negative and the positive, or the constraint and the possibility context of, where do we need to be, might we want to be concerned in terms of the legal implications, but where are there possibilities at the state and local government? And I'll say, Dana, if you're ready, if you want to start, and then we'll do Dana, Al, Rachel, and then Sheila, if that works.
Yeah. So I think it puts us in a concerning place. So if you think about the Gulf, you think about Louisiana. I think this was brought up earlier where, Louisiana was given primacy. We expect for other states to follow suit. So it would, in communities that, are looking for like a federal intervention, it makes it tough. I think on the positive side, one of the things that we did when New Jersey passed its cumulative impact law, for example, the environmental justice movement across the country was really excited about that. So how, do they start to do that same thing at the local level? And again, like not knowing the outcomes of elections, it was like, let's prepare ourselves to operate locally. So what we did was, I saw where the Sabin Center, Michael Gerard, was putting together like these local model bills. He didn't have any related to environmental justice. And so I thought, we've been trying to get people to sort of proactively write them on their own. What if we did it for them and they can download and adopt them to meet their needs? So we put together this 5 model bill package. It's called Dismantling Injustice. It focuses on setting up an environmental advisory board in your community, truck pollution, the documenting, like the pollution process. I can never remember all 5 and I should have looked. But there are tools there that communities can use to do that. We also developed resources, toolkits for people to start like building champions around these at the local level, how to hold community meetings, et cetera. And so I think that's a positive outcome or a positive resource that is provided to communities to help them, again, with that both and kind of strategy.
And Dana, will you just share the URL, the website? Oh, so it's dismantlingjustice.org. So folks should look for that, and I can try to put it in the chat in the Huba. Al, do you want to
Sure.
jump in?
Yeah, on the question of, how do these federal decisions have implications on state regs? At least I'm not considering, I'll leave to Sheila maybe to talk a bit about like SFFA. But those other cases, I mean, if you are a state entity and there's state law, I mean, all like the state question, the administrative law questions around the Supreme Court cases, they all revolve around what did the Congress say that you should do, and are you exceeding that? And if you have good state laws that have EJ enshrined in them, for example, like in California, and there's some in New York as well, New Jersey, these theories should not affect you as much because the law, the intent is very clear, right? On top of that, I mean, I think where it might come up, and so I mean, at the local state level, you have to worry less about the administrative, unless there are programs that are being administered. And this gets what Dana's saying, that are being administered as part of federal delegated responsibility or something like that, right? Like the enhanced oil recovery stuff going on in Louisiana, and like that stuff is like that has a federal net to it. So some of this stuff could still be caught in that net. But as far as like if you're at the state level, these cases should not apply. And the other thing too is that it depends on what your state laws are, right? And there's more accountability. I mean, like states have been able, as I mentioned, be able to pass like human rights laws, even at the city level too. Civil rights protections that go beyond or similar to what the federal level are, with clear disparate impact standards in there, right? And so it depends what state you're in, but these cases don't really apply to those state cases again. So I mean, that's the only thing I would say.
Rachel, do you want to go ahead?
I'm happy to toss to Sheila to talk about the implications of SFFA,
Sure.
because I think that there are some, and I think there are some possibilities as well, and I'm sure Sheila will share those.
And happy for you to add to. So I would just say very quickly, so the SFFA does constrain states and localities because it's about state action and using race, and when you can use race. It was an equal protection case. And the question is to think about when you can, it's not that you can't, but when you can do so. And there's some openings, right? One is to address past discrimination. It's back to how do you prove discrimination? And is the state or city involved in discrimination? There may be other interests, and what the court seemed to be saying is that they have to be measurable. This is why I keep coming back to social science, that the university's interests were not how do you measure whether you're training good leaders, et cetera. I think in the environmental and climate justice arena, we can measure stuff, right? And we have good science. So that's number one. Number two, I do think that, the cumulative impact bills in New Jersey and New York are a way of perhaps sidestepping SFFA, because they're not mentioning rape, but they're getting to the heart of what the EJ movement has been, what our communities have been under, which is this burden of cumulative impacts. And so those are the two things I'll say very quickly, and then I'll allow Rachel to weigh in if I've missed anything.
Yeah, I would absolutely 1,000%. It's interesting, Sheila, that you mentioned sort of social science. If we think about, again, the origins of EJ, if we think about the United Church of Christ report that literally gave us the story, gave us the causal story. Like there were so many areas in the late 1980s where you knew, if you were paying attention, that race had so many implications for people's lives. But when that report came out that said it was race and not class, where the correlation between hazardous waste and communities lie, like that was the sort of the spark that just made the environmental justice, sort of conflagration of urgency emerge. And so I think the EJ movement has been multidisciplinary from the beginning in ways that are quite distinct. And I think you're exactly right that with environmental justice, there are so many different ways to use kind of measurable differences in the experiences people are having with with both the protection and the protection from harm, but also the presence of amenities. And we want both, right? I mean, communities should be not just not being harmed as much, but should also be enjoying, sort of the opportunities for the opportunities to thrive that are often denied as well.
Thank you so much, Rachel. And I feel like you're bringing us home and bringing us back to our roots once again. And I think, and in the spirit of bringing us home, Sheila, if you want to share a little bit about the working at the local and hyper local level,
Yes,
and
so-
grounding us there to close
Exactly.
us
Real
out.
quickly, I think more cities are building climate justice into their adaptation and climate plans. I've been heading up the work in New York City. We just published a report that's very social science heavy called Advancing Climate Justice in New York City. And we construct a new kind of score that combines